Good afternoon and welcome to the Health Subcommittee meeting of the California Paraprofessional Program Working Group. I'm going to just see. Oh yeah, Carolyn, I'm going to move Carolyn. Okay. So I will begin by taking roll. McRae.
Here.
Robinson.
Here.
Shining.
Here.
Great, thank you. We're all here. And should we see if there's anyone in the public that wants to make comments?
Yes.
I see that we do have someone. And if there's any, we have one person who's indicated they want to make comment. If there's anybody else wants to make comment, please raise your hand in Zoom. I'll go ahead. And Dana, did you want to limit the time? If we have only one person and we have lots of time,
I think we should. Let's let it run.
Okay. Okay. Hey, Andy Katz.
Hello, good afternoon. Can you hear me?
Yes.
Yes.
Hi, thank you, members of the Paraprofessional Working Group Health Subcommittee. My name is Andy Katz. I primarily practice employment law and workers' compensation. And through those practice areas, through the intersections of employee benefits and independent medical reviews and health navigation that comes up with workers' compensation, that's how I bridged into doing health advocacy. Prior to practicing law, I also worked for 10 years as a government relations director for a lung health organization, and I currently serve on the Berkeley Health Commission. So that's my interest in this issue as somebody who cares about public health and the right to health care. And so I wanted to express some comments about the justice gap as it relates to health. There is a justice gap as it relates to health, but not all of these tasks are necessarily performed by lawyers. And some of these tasks that are performed by lawyers, there exists a very robust network of nonprofit advocates, some that specialize in Medicare advocacy for Medicare beneficiaries, some for Medicaid or Medi-Cal beneficiaries. And there's also a private network of health advocates who are non-lawyers, primarily nurses, doctors, and social workers. This interdisciplinary field, I think, is a very interesting thing to carefully consider with regard to whether paraprofessional licensure makes sense. What I am concerned about with regard to the areas where practice of law could overlap is that in an amount of high controversy, in an amount of a pattern and practice, we would have problems with the ERISA claims process. As you may know, employer-sponsored plans have exclusive jurisdiction in a legal dispute in federal court under ERISA. So the California State Bar would not have jurisdiction to change the legal representative in court for disputes that ultimately go to litigation. For insurance disputes that are privately individually sponsored, these become very complex matters where bad faith law comes into play. And I would be concerned about paraprofessional representation for those advanced matters. However, I think that the best solution here is to carefully consider the relationship of any future program with the existing industry of health navigators and health advocates who come from an interdisciplinary background, primarily not lawyers, primarily social workers, as I said, other allied health professionals. And I think it is very complicated whether a new licensure program would mandate them becoming part of this licensure, or what it really means to have a side-by-side licensure, which I think would be dysfunctional for reasons I could answer questions about. Most importantly, I think there are existing nonprofit services that really are the people who serve the people who are identified in the Justice Gap study. So the people who we're concerned about at close to the federal poverty level, they're not going to be able to afford the $150 to $200 that is already the market rate for this health navigator profession. They have a very emerging private licensure system that's already existed, a private certification that by the Patient Advocacy Certification Board that's been in existence for a few years. I'm not sure if the state bar stepping in would solve that issue. So my main recommendation to wrap up would be to make recommendations to the Department of Justice, to the state bar, to the Department of Managed Healthcare, any other appropriate regulatory agency with jurisdiction, to help consumers get navigated to the existing free services that are there to help them. What I find the most often in my practice is that people come to me with no idea what exists. And I figure out if what they need is something that another free service can do before I offer services for an hourly rate. If there is a service that is going to go to litigation, I figure out what is the ERISA process, what is the very critical matter of making sure that the record that will be sealed and not be able to be reopened in an ERISA litigation is prepared very carefully. And if you do start to consider those types of things, I think the mechanism and the analytical method for preparing the record is something really important to think about. So I would caution against doing a paraprofessional licensure for most of these tasks, but to think about the bigger picture and how do we work with the existing nonprofit services, how do we work with the existing health navigator industry, and how do we help those relationships work more functionally. I do think that there is an open way of including health debt collection. I think that could be further studied in the debt collection area. And I think that would really serve people well if paraprofessionals doing debt collection for medical debt could work in this area. I have some reservations that there might be, and I don't know the legal answer to this question. I would encourage study of what circumstances, what advisements need to be investigated when somebody might still have an open statute of limitations for ERISA or a privately sponsored insurance law. So I think that would be an open question that could happen in the civil debt process in a separate subcommittee. But those are the nature of my comments, really to avoid experimentation in this area, but to work constructively with the existing healthcare regime, the regulators, and the existing nonprofit services, but still to be facilitative for paraprofessionals to help defend people from civil debt collection. Thank you. And I will remain for any comments and questions.
Thank you, Mr. Katz. Linda, is there anyone else from the public who would like to be heard?
No, there's not anyone else. Did anyone have any questions for Mr. Katz, or should we move on to our?
At some point, I know ERISA came into my mind, and at some point, I think, depending on where we want to go, it's going to be a big hurdle. You know, Medi-Cal, Medicare, if insurance kinds of complaints about, it's just something that we're going to need to think about. And I was hoping we could throw up the, do you have the slide of the list of the areas we were talking about, Leah?
I think I can pull that up. Hold on a minute.
I know people who, like Mr. Katz, deal with ERISA issues are few and far between because it is impossible. It's federal, it's impossible. It's climbing up a mountain, and there's nothing that mountain can be moved by. People have tried. If we could make that easier, if we could make ERISA go away, there'd be a lot of happy people all over the country.
So these are the areas that we've preliminarily said that we would include and get more information about. The first one has, after our conversations with experts in this area, has sort of been split into two. Not just medical billing, but medical debt defense. So shall I go into the people with whom we've spoken?
I think
Okay,
that would be helpful, yeah.
so I had an opportunity to speak one-on-one with several of these people, and then Linda and I got most of them together on a Zoom and had a chance to really dig into our questions. It was Charlie Gillig, the VP of Operations and Legal Technology from Neighborhood Legal Services of LA County. Jack Daly, the Legal Aid Society of San Diego County, who brought with him a billing dispute expert named Micah. Last name began with W. Linda, I didn't catch her last name. Henry Martin, the director of the Watsonville Legal Center, who's embedded at a federally qualified health clinic, Salud para la Gente, in Watsonville. And then just before this meeting, Andy Katz, who just spoke, and I had a chance to speak based on the letter that he sent. There was broad consensus from this group of people on the Zoom, and Linda, if you disagree, please tell me, that there are other ways to close the justice gap in this area than licensure. Largely because in California, every single geographic area has a health coalition that provides non-income-based services in these areas. And one of the problems is driving consumers to those HCAs. And some ideas about how to accomplish that were discussed with this group. One of the things that came out, two of those experts who have been attending several subcommittee meetings, including consumer debt, two of them mentioned their surprise that medical debt defense was not assigned to the consumer debt subcommittee. And they were wondering why it could not be, with the caveat of this ERISA issue. And the idea that in the area of judgment in medical debt defense, ERISA arises and it would have to be trained for or excluded. So one of the things that I was hoping to accomplish today was to discuss that very issue. Should we ask the Consumer Debt Subcommittee to take on medical debt defense and dig deeper? I'm sorry that we're a little late getting to them. I think their work is a little ahead of this subcommittee's.
Well, yes and no. I'm on that subcommittee and it did come up in the last session. And so we discussed 4 different options of that kind of thing in court, out of court. We discussed that a lot. But the issue of which kind of consumer debt, there was a list put up and we talked through it, but we're going to need to talk through it some more. So it is on, those kinds of things are all on the list. We talked mainly about credit card debt, but it's on there.
So
Yeah, we didn't exclude medical debt, that's for
No.
sure.
No, we did not.
So maybe before we go further with this, Nicole, are you willing to share your experience?
Absolutely. So thank you, everyone. And I apologize for not being a part of those earlier conversations. And I accept that I may be the voice of one in this case. In 2018, I was diagnosed with stage 4 metastatic breast cancer. Prior to that, 2014 is when I was originally diagnosed with stage 2. But in 2018, I was up against having to battle with my insurance company, not knowing. So once I received that diagnosis, there was a treatment that I needed because my cancer in one area spread to the bone in my back. So I'm really impassioned about this because my insurance company denied me treatment at this procedure, the process, step therapy. So my oncologist recommended a certain drug for medication for treatment for my bone, for bone metastases. But my insurance company, they wanted me to take a drug, of course, that would be of lesser cost to them. Not knowing my medical history, not knowing how that drug would affect me, so we did a first appeal with my oncologist, which was denied. And the most disheartening thing is the description that came back to say, not medically necessary, with stage 4 cancer, not medically necessary. So my oncologist said, if you want to try to appeal it again, she pretty much had given up a little bit. I mean, we gave studies to kind of support why I needed this drug, this treatment, but still, so I set out on the path. I had to self-advocate for myself. So I think I mentioned before to Linda and that I took out on this journey because oftentimes as consumers, we don't know that we can appeal a decision, right? So not even someone with a chronic illness, we just, if an insurance company says, okay, you need to take, we're going to give you this drug. Some people just take that, not knowing the adverse reactions that they're going to have based on their existing medical history. So after I submitted a number of appeals, I even sought the assistance from my representative, yes, to help me in this particular area because there was a delay. So I was able to start treatment in other areas, but for the bone metastasis, there was this delay in the process or being just denied. So I took to social media. I used it as a platform. I created an online petition to assist in allowing this insurance company to change the decision because they weren't. They were, forgive my French, they have decided just this is what, this has to fail first, this fail first method. And it's just so disingenuous because when you're faced with stage 4, it's like you're up against a clock, right? So the severity, and I have to admit, I don't know the statistics or numbers when it comes to cases, but knowing even to dive into the medical debt piece as well, my debt is in my when I was first diagnosed, I was in graduate school. I borrowed extra money against my student loans to help me pay for my treatment, not knowing the cost of treatment, right? And I consider myself the forgotten middle because a lot of the programs are geared towards lower income status individuals, right? My medical debt, I have multiple collections accounts. I can't even make it through a whole year, like with flexible spending through my employer before it's depleted already, right? And so then I'm working with the hospital or even hospitals. Can you provide me with some kind of assistance? And a lot of times that information just isn't available to right off the top to cancer patients. It's not saying that this is available to you right off. You really have to dig and research. So I was one of those diggers, okay? And got a list of resources, but each time I contacted a separate resource, it may be income related that it's not available to me, right? Because the income limit is very, very low. And so for me, there is a need. And like I said, if I have to be the voice of one to advocate for the paraprofessional in this area, luckily my petition that I created and having people to chime in on social media saying, well, this is unfair. And then they wanted to have a conversation to say, hey, okay, we're going to allow you to have this treatment. But even so with that, being a stage 4 metastatic patient, I have to get scanned every 3 months, right? To make sure there's no more spread to different areas. And even with my scans, I get denied for my medical scans. They're wanting to know, why do you need to have a CT and a PET scan and a bone scan? So my struggle is just, I mean, it's one thing you're having to battle just to stay healthy, keep yourself in this place, but then you're having to battle other issues as being a patient. And so I just wanted to be able to share that, to say there is a need. I would utilize that because I'm strapped in this, financial toxicity as a result of my treatment, and which started back from 2014. And then it only elevated, and I panicked because when I was re-diagnosed, I was like, oh my gosh, what am I going to do? I know the struggle that I had being originally diagnosed and what I used as an avenue to help me pay for treatment. Like one particular drug I can remember, a little vial, $5,000 that my insurance company didn't cover, right? And me having access to a credit card, a nice substantial amount, I charged that treatment on a credit card, right? And so it's just like, I try to keep myself in a place so where I try not to focus on that thing, but that thing is big, it's an elephant in the room and it's huge, and I'm like, and I can only do one thing at a time. So I'll, I'll start with the little piece first before I try to move to the big piece. So I thank you guys for, allowing me to share my story. I mean, so I'm an advocate, I'll share my story, I even participate in going on Capitol Hill, I mean, anything, for funding, so it's a topic. And like I said, it's the forgotten middle, the middle that it's a missing piece. And you're right. There are agencies out there, but sometimes it's a matter of educating and it's not knowing that some of these things are available. But then when you find an organization, then it's like a stab that you don't qualify because, your income, you're over the income limit. So then you're like, wow, so it's a day-by-day process for me. But I thank you guys for allowing me to share my story. I'm currently in treatment. As for, metastatic stage 4, there's no cure. So once a treatment stops working, then your oncologist, we try to find something else. So I'm all about, I want to live, yes. And I shouldn't have to battle with my insurance company, So that's my story, guys. And I thank you for allowing me to share that.
I really appreciate you putting the personal twist on this.
Yeah. Thank you for sharing that personal story.
Dana and Linda, can I ask, just because you've had all these conversations, is that your view based on what you've heard is that there are organizations out there to help the Nicoles, regardless of her income, that the issue is connecting Nicoles to these services?
That is what we were told. And there's a couple of people I see in the attendees who represent those services. I see that. Oh, and I don't know if we want to hear from Jack Daly again, who is one of the people that Dana and I spoke with and who spoke to the subcommittee early on. So if you're okay with that, we can bring Jack in.
Let me also add before Jack speaks that in addition to these HCAs that exist throughout the state that are not income qualifying, most of the bullet points on our list do not require a law degree to practice in those areas. And there is a market out there if you want to pay somebody, the healthcare navigator, professional health advocates. And there are a couple of certification programs that have cropped up if you want to go even further and say that you've been certified. UCLA has a patient advocacy certification program. And then there's a group called the Alliance of Professional Health Advocates and the Patient Advocate Certification Board. So you don't have to have a law degree now. And I think there is some concern that we are going to disrupt that market by requiring licensure. At the same time, if somebody wanted to go get licensed in consumer debt and they were already a healthcare navigator, there's nothing that would make them stop being a healthcare navigator if we don't require a license. So in other words, they could be a consumer debt paraprofessional and keep doing their health advocacy or health navigation. So I just wanted to add that before we hear from Jack.
I appreciate it. I don't want to take too much time. I've spoken with Linda and Dana and the subcommittee multiple times. Really appreciate opportunity to share. I apologize, Ms. Robinson, I only came in. I was coming in from another meeting. I missed the public comment section and I missed the majority of your testimony there. And I really appreciate the opportunity to chat. I just wanted to chime in that as I think Dana mentioned, the Health Consumer Alliance is an alliance of 10 legal aid programs across the state that have dedicated health consumer advocacy programs, broad-based health consumer advocacy programs that do not have income and asset limitations. We serve folks of all income and assets. We have certainly many clients that would fit under state bar income and asset criteria, but probably in the neighborhood of 10 to 15% of our clientele that are above 400% of the poverty level, and are actively, promoting our work to all populations. For example, we've got subcontractors that work specifically to engage employers and inform them of the availability of our services so that we can get the word out about our work. And whenever we have the opportunity to get our name on and our contact information on notices to managed care beneficiaries, to all covered California beneficiaries, we try to promote that. So anything, we certainly would love to partner with the bar further on getting the word out about our services. I just wanted to add that, and I'll leave that there. Thank you so much.
Can I ask a question, Jack?
Sure.
I just want to confirm that what the Health Consumer Alliances do is not just deal with the billing issues, but advocate regarding the issues that Nicole had with denial of access to the care that was recommended by her doctor.
Absolutely, it's a good question. Yes, when I say broad-based health consumer advocacy, we really focus on two big buckets of work. Really, one is we want to make sure people can access coverage, so that's a lot of eligibility work and keeping people on programs that they qualify for, and then it's making sure that folks that have coverage, regardless of the source of that coverage, can access the care they need. And so that means when people are denied services, procedures, referrals to specialists, when they are having difficulty accessing medication, when their insurance plan is telling them that the amount of copay or cost sharing they have is X, and that X is large, and the patient believes it's Y, we can get in there and help them dispute those cost sharing issues, dispute denials, delays, terminations of care. This is the bread and butter of the work that we do, and we use all remedies and available to consumers to do that.
Thank you. So Nicole, when you were advocating for yourself and looking all over the place for where to get help, you didn't come across any of these healthcare alliances, or did it sound like you did and maybe you were denied because of your income? Or
So I was provided a list through Susan G. Komen. So I don't know if they might have been on the list, but I was provided a list through Susan G. Komen. And then but my urgency was a little bit more, right? I needed care now, right?
Mhm.
So once I got a few denials or a few, turn downs, I'm just on my, I'm just plowing forward to do whatever I have to do. But a lot of when you go to maybe like your doctor, there might be a social worker that might be available, but not familiar with a lot of these. Just hearing now, not a lot of availability, or it's not out there in the open where I could actually reach it. So it's good to hear that this is available to me. But in my experience, what I have experienced thus far, I hadn't been able to take advantage thus far. So I was provided with a list of resources.
Yeah. And this is Carolyn. I would, no, and I understand that issue. And thank you, Nicole, for being so honest and everything. It's hard. But that is one of the things. And I don't know if Jack can address this, or Andy. I've known people, it's the same sort of thing. When you're a cancer patient, there's no waiting for 2 years to get to your court date. And I know even today, if you file a court case, it takes 30 days just for the other side to respond, and probably take you 2 weeks to get everything on file. So no, I mean, I think New York is looking at these social workers and trying to grapple with what social workers can do more in terms of going to those care, insurance companies and saying, but that's, and it begs the question with what the slide was, are we talking about insurance companies? Are we talking about doctors and hospitals and medical providers? I know some of them are really responsible for the $5,000, the $5,000 bill. They're like, oh, that can come from your hospital, not your insurance company. I don't know. It's so complex. I'd like to hear more about your experiences, Nicole, and maybe Jack, if you can talk about how do you get that treatment? How do you deal with those situations where someone needs a surgery? They need end of life care. They need, renal dialysis immediately, like next week.
So let's see. Last month I had to get my re-up for my scans. So of course, lately in my recent submissions, my oncologist just has exit PET scans, right? Because usually it's a bone scan, a PET scan, and a CT. So because of the cost, they don't want to provide all of those things. And so my oncologist, okay, well, we'll just go with the CT. That'll tell us enough if it's spread anywhere else. That'll give us enough information. But why? Why should I pay into it, why should I have to not have that available to me, right? To take that deeper look to see if my cancer is spreading outside or going to other parts, if this is really going to tell the story or the picture. So it's just a little tough.
And Ms. Shining, and by the way, Ms. Robinson, thank you for, again, from sharing your personal experience. Healthcare is an incredibly confidential and private matter, and for you to share this and your experience is so valuable, but also very brave. So I want to kind of acknowledge that and appreciate your sharing your story. To answer your question, we have the benefit in California of having some pretty incredible oversight, mostly through the Department of Managed Healthcare. They manage probably the majority of the lives that are in managed healthcare in California. They have really, they are one of our partners and funders. The Health Consumer Alliance benefits from partnership with the Department of Managed Healthcare, and they have expedited external review procedures available when folks are facing critical and urgent services needs. And so if a case were to come to us in that scenario, we would immediately escalate to our contacts at the Department of Managed Healthcare, and likely within a day or two have review of the plan's action and be able to get a disposition. So it's typically within 72 hours we can get an expedited case. But as many of my partners at the Department of Managed Healthcare, the attorneys there know, I've spent many Sunday evenings on the phone with them working on critical cases, especially during the last year. Many critical situations have come up related to COVID and vital access to care that has been really critical to address immediately. And so really appreciate their oversight and their leadership. But we handled those, unfortunately, those situations very often and bring immediate resources to try to assist. We do not have a magic wand, and I don't want to pretend that we do. We have to hold, especially with employment-based healthcare, private healthcare coverage. These are very contract-driven, and the terms of the contract govern. And so there are some requirements, obviously, that we can hold the plans to, but where the contract has limits, we sometimes are limited by those limits. Now, of course, there's tons of room for interpretation, and that's where advocacy comes in. But it is an important resource to have available to consumers in those moments, because in those moments when an insurance plan says no, it is very isolating, very scary, and people immediately look to try to finance this themselves because they need the care. And I think Ms. Robinson mentioned that she immediately turned to credit cards. That is an incredibly common experience. And by the way, a good part of our work is for folks that had to turn to credit cards, we then go back to the insurance company and try to get them to cover something that should have been covered in the first place. So again, it is very complex. There's a lot of aspects to it, but there are resources out there, and I'll stop there. I don't want to occupy too much time.
Thank you. And this is Andy Katz again, and I would like to agree 100% with everything that Mr. Daly commented about, and to also thank Ms. Robinson for sharing that story. It's extremely tragic that this is not, you're not alone in insurance company abuse of medical necessity denials. And I do see this quite often. And some of this is a matter of advocacy is able to assist, but it's also important for folks to understand that this is not just a simple question of advocacy in and of itself. The medical industry and this whole system of independent medical review is guided by a library, what we as lawyers would refer to as a library of medical and clinical guidelines. And I think there are some major ethical decisions that are involved in how doctors and insurance companies arrive at their interpretation. And this is often a matter of regulatory discretion when an advocate or an attorney is submitting something to the Department of Managed Healthcare's independent medical review program. Like Mr. Daly said, there is an expedited process for emergencies, and you can advocate to move things more urgently. But at the end of the day, something like what Ms. Robinson experienced with step therapy is generally recognized in the clinical guidelines, and even the Department of Managed Healthcare will often rely on it. And most judges, especially judges that are bound by a record, and when you're preparing a record for an ERISA case, you have to make sure that all of your references, all of the evidence that is supportive in the medical literature and by the physician is in the record at the time of the appeal deadline passing, or else that issue cannot be raised further in the process. It's a little more, independent medical review is similar, but it's much more expedited. You're submitting a package right away, and there isn't a back and forth quite the same way. But at the end of the day, a question like the ethics of step therapy is a question that is a policy question. There is a bill in the legislature that some pharmaceutical companies have sponsored to have additional relaxation of step therapy. And I think it is an important debate, but it's that particular medical necessity question is unlikely to be something that would be simple in one case to overturn. This advocacy is complex, and that's why I think we see a lot of doctors and nurses doing this work on their own, as well as lawyers who do this practice, heavily relying on the patient's doctors to inspire them to be better writers when facing a denial. So those are my additional comments here. Thank you.
And let me just emphasize what Mr. Katz said was so important: the collaboration with the provider. We are not clinicians, and many of these cases turn on a clinician's perspective. And in order for what we help the clinicians do is articulate the appropriate medical necessity standards and elements that would be helpful to establish, if present in the patient's case, would be helpful to establish the need for the particular service. And that takes a lot of collaboration between the advocate, the patient, and the provider, and a willingness on behalf of the provider to engage in that. And that is time consuming. That is not currently is not billable for those providers, and it can be, especially for our lower income populations in the Medi-Cal program, can be challenging to get providers to engage in that level of advocacy. So I just wanted to support what Mr. Katz was saying and emphasize the importance of that close collaboration. That's why medical legal partnership models have been so vital. I believe Mr. Katz is a walking medical legal partnership, if I'm not misspoken, if I'm not incorrect. So a big shout out to those models, because they are really very effective.
So I guess my question for Jack and Andy, Mr. Daly, Mr. Katz, my question would be, how, it just seems to me, because I know hospitals have social workers in them to help with these kinds of issues, but I know every time again that I've ever gone to talk to them, they're overwhelmed, they're exhausted, they're just really, really called upon for everything. And it just seems to me that, is there a way to find someone who is that person, that social worker who looks at it and goes, you need an attorney for this, I've written, I need some. Is there like an in-between ground to give that person an extra boost of ability before it escalates to the level that or because there are so few qualified, attorneys to do this? How can we thread that needle and give that person a boost, the licensed social worker, and say, here's the stuff you can do that'll move the ball faster or further?
That's a tricky question that I honestly don't know if I have the full answer to. I think social workers, the contacts for patients in these experiences are often frontline workers, office managers, lead nurses, charge nurses, social workers, care coordinators. Depending on their role, they may have a varying amount of resource and time to take on this task, to fight an insurance company, to have the back and forth with their utilization management team as to why something's necessary, why something's not necessary, and take someone through internal plan appeals, external plan appeals. So I don't know that I can really adequately answer what additional resources we could give those individuals, other than the benefit of more, less response. I mean, I think it's a dedicated role within those organizations. I mean, it's some patient representative staff at hospitals get involved with this a little bit further. Referral specialists at clinics they're a great source of referral to us. Whenever I can meet a referral specialist at a clinic, I treat them like kings and queens, because they are where the rubber meets the road. in our current managed care systems of healthcare. They are where denials happen. And for that referral specialist to know, oh, this patient has rights, even though this plan is saying no, this patient has rights in this moment to push back. Instead of going back to the patient and saying, hands up in the air, I guess they said no, or going back to the provider and saying, well, the plan's not going to cover it, so come up with an alternative method of treatment or an alternative test, something that you didn't think was sufficient originally, but the plan's not going to cover the thing that you think is sufficient. So it's really important for those folks to know that the patients have rights and to be able to connect them with folks if they themselves don't have the resources to fight it, on their own. So I don't know if that's a great answer to your question. I apologize. It's a really tricky question.
And I would likewise agree with that. It's a very challenging situation when sometimes the insurance company, whether even sometimes an attorney letter does influence the insurance company to just let down, but sometimes I just get a non-referral and I get very non-responsive responses and simply have to go to DMHC just like a non-attorney would. But I generally think that the solutions here are regulatory requirements that require insurer disclosure of the existence of a Health Consumer Alliance affiliate. And that would solve the first problem of a consumer not even knowing where to go. And the other recommendation of allowing billable time for the provider, because in almost all of these circumstances, the system of prior authorization requirements of the insurer applying utilization review guidelines puts an onerous burden that the physicians are struggling with, because they don't get to bill for this time, and this is really part of patient care. So it becomes a legal dispute only with the dysfunction of this communication matter. But I think that at the end of the day, this is a what we call a medical-legal question, and the doctors are essential evidence in the first instance. So finding a way to provide better incentives, even when I'm working with somebody, if we can't find a provider, even when I'm working with a consumer client, if we can't find a provider who can actually articulate what needs to be said, there's nothing that can be done. Unless this is a satisfied record that should already go to an ERISA filed case. But in most of these circumstances, I think we have to look at these incentives that just aren't working. The insurers aren't helping people get to their advocates like they should, and the doctors don't have enough of an incentive to devote the attention that is sometimes required by insurers in these very difficult situations.
I'd like to ask a clarifying question on the topic of medical debt. It sounded like, I think it was Mr. Daly that talked about helping people, like when they charged something to a credit card, to go back and get the insurance company to cover it. So what's the line between assisting with medical bills as they come in versus the part that consumer debt subcommittee?
Yeah, I think that's a really great question. We have the benefit within, for example, in Legal Aid of San Diego, we have the benefit of a what I call a rock star consumer protection team, and we always analyze these cases first through the lens of whether there's a coverage option available to the consumer, meaning can that debt or that bill be covered by that consumer's coverage, or if it has been covered, has it been covered completely, meaning if there's cost sharing, has the plan appropriately calculated the cost sharing that the patient's responsible for, and thus are legitimately billing a portion that the patient is responsible for. Now, if that's the case, the patient is responsible for it, and there's no further coverage option through the insurance. And ultimately, it really comes down to advising the consumer about what consumer protections they may have with regards to that debt. Then that would be a matter for our consumer protection team, and I would turn that over to our consumer protection advocates. If those if there is no coverage option available through insurance, and that is an outstanding debt that consumer is going to be responsible for, and or there's some ongoing dispute about whether that consumer should be responsible for all of it, then that becomes a consumer debt matter. We can advise the consumer just very basic tenets of what their consumer protection rights are with regards to medical debt, and what the billing prohibit protections are related to medical debt. But we quickly, especially at the moment anyone is being harassed by a collection agency or a provider, and or is subject to a suit as a result of a debt, that quickly gets handed off to our consumer protection teams. Now, different programs handle that differently. Our partners in Los Angeles, they handle that all internally within their health unit, and similar, the slight variations within our HCA network. But there, that's from an analysis point of view, you're basically first going to be looking for a coverage option, and then if no coverage option available, then handle it through the lens of a consumer protection advocate. And
Thank you.
yeah, by the way,
does anybody have any other? Yes.
I was just going to note that if there are, there may be other folks on the line within our networks or outside that may have some value or insights to add to that whole analysis. I will certainly want to hear from them.
Leah, what were the other areas that we wanted to talk about? Were those things that our two visitors could help us on?
Do you mean Linda? Are you wanting to see the slide again?
I forget. I'm sorry. Linda, do you have the slides?
Because I think that what I'm hearing is, and Dana, jump in, it sounds like in this particular area, there is a robust infrastructure for all of these three bullets that is not income-based through these HCAs. And therefore, there may not be a need to license paraprofessionals to work in this space. And in fact, it may be detrimental because there are already non-lawyers doing this work. And it sounds like one of our critical issues or contributions in this area may be to figure out how to make sure consumers know about the availability of these HCAs. As Nicole said, she didn't know. You get a long list from Susan Komen, and if you don't happen to hit one of these HCAs and then you get denied, you're just not going to keep going through this long list. So that's what I'm hearing. With respect to Linda's last question on the consumer debt piece, I think I'm curious if the HCAs also will handle a straight consumer debt issue, meaning there isn't a current ongoing medical condition, it's quote unquote over, but I've racked up, $100,000 in medical debt, and I need help with that. That's where I'm unclear. Will the HCAs also kind of take that case and help somebody with a quote unquote straight consumer debt problem, not wrapped up in a coverage issue per se? And if the answer to that is no, then I do think we want to make sure on this general civil side that we're looking at the particularities of medical consumer debt, because we haven't done that.
Yeah, I think we're about to do that though.
And so maybe that's a question for Jack or Andy. Yeah. Someone just comes to you, it's not a coverage issue, it's not an issue with the insurer, I just have a ton of medical debt. Is that a case that you take on through the HCA non-income delimited portion of your organization's work?
So my practice does not handle consumer debt, so I would not handle that because I don't have adequate competency in a pure debt issue. One question that I would raise in terms of how to adequately prepare a paraprofessional. Oh my gosh, did you hear the first part of my sentence?
I heard prepare a paraprofessional, and then you dropped off.
Okay, I'm not sure when I was muted. So to try to pick up where I might have been muted, the concern that I would have about a paraprofessional in terms of the training and regulation and scopes and tasks that perhaps the overlapping members of this committee can take over to that subcommittee would be how do, if this is feasible, how do, are there threshold ways to issue spot the existence of a potential ERISA or contract claim to revisit the medical necessity? So if there is a legitimate medical necessity dispute that can be revisited, reopened, claimed, ERISA is very complicated in terms of exceptions to the strict deadlines. Normally these deadlines are rigid, but the Ninth Circuit recognizes doctrines of estoppel, something that I casually might refer to as moving the goalposts as a separate theory. So those are recognized theories in the Ninth Circuit that require a lot of legal research and understanding to actually litigate, but it might be possible. I can't really say one way or another because I don't have enough experience in consumer debt. So I highly recommend assessing what kind of screening should a paraprofessional handling consumer debt do to screen out, well, you know, can you still can you still move to set aside the judgment, first of all, if this is in state court? So if this is an individually sponsored plan with a dispute in state court, are we still in the 6 months where you can move to set aside that judgment? After that, it's probably final. But maybe not. You know, there is a contract statute of limitations for 4 years. So I think further study of how to help train, whether paraprofessionals can be trained to issue spot that medical necessity issue as an underlying matter. But if the service was received and it's just debt, I don't really have concerns. I think this would be extremely important to assist people who are caught in the justice gap and need help resolving the debt. So my just to be clear, my only concern in this area is helping to train paraprofessionals to adequately issue spot the possibility of another underlying necessity claim not having lapsed, so that they can be advised to consult an HCA or another attorney.
Got it. Thank you.
And to your question, Ms. Wilson, I don't have a good statewide answer because there is some variation internally within our organizations as to whether the non-income tested teams, health-focused teams, we call them health consumer centers or HCCs, would take on a pure debt case because of the varying levels of focus and specialization within the agency. San Diego, we have the benefit of a wonderful team, specializes. They have the competency to handle a pure debt case. And we have competency up to a level. We don't step over our bounds because we have our specialists. Other HCA programs have that competency built into their HCC. But just let me take a step back and more broadly say that, 20 years ago, over 21 years ago now, our health consumer advocacy work was done within the pockets of our government benefit teams and our at legal services organizations, and they were income and asset tested, so means tested eligibility for our services. I just want to put a pin in the idea that it took enormous effort to go out and identify, sources of funding that would not limit us to only lower income populations in order to fulfill our stated mission of ensuring access to care for all Californians. To make that work, we had to go out and identify those funds in order to leverage the experience we already had and leverage the insights and the experience that our teams had internally. that same model and that same approach, I mean, that model has served HCA for the last 21 years, you know, hundreds of thousands of patients that we've been able to represent in during that period. That same model and approach, I would certainly encourage to, it could work for consumer protection as well. We have amazing insights and expertise within our programs doing this work for low-income populations. I think the Justice Gap study accurately identified that this impacts low to middle income populations as well, that may not be able to benefit from you know, pure legal aid program, you know, income tested consumer protection services. I would just urge that there be some consideration to in the kind of following in the mold of the HCAs, leveraging that built-in expertise and insights, helping lift off those limits, provide and help identify resources for programs doing this work already to take on those low to middle income populations that we've been so expertly serving in the HCA, but haven't maybe been able to serve more broadly statewide on these issues of medical debt. So, you know, I'm not involved in the other subcommittee group. Other folks are in our networks, and I've certainly been weighing in there. But I just want to kind of put HCA as a model for that has succeeded in leveraging kind of the wonderful expertise that the State Bar and LSC has helped develop for the benefit of low-income populations, and allowing us to expand that benefit to middle-income folks as well. Thank you.
Thanks. So Dana and Carolyn, I'm thinking, or maybe Linda, were you going to say something?
No, go ahead.
And Nicole, I'm just thinking about when General Civil sent enforcement of judgment and wage and hour claims, sent it back to employment. Thinking about the letter that Judge Yu wrote as the chair of the pilot subcommittee to the licensing subcommittee. So I'm wondering about a letter, which would be an email essentially from this subcommittee to General Civil, outlining the issues, saying, you know, we fully explored health. We found that there's this network available for many of the issues, that the needs that have been identified, and we're going to make some recommendations around increasing, you know, consumer exposure to that network. But we would like explicitly for General Civil to address the issue of medical consumer debt. It might be a good way to capture the direction from this subcommittee in a somewhat formal way. So I don't know, Dana, as the chair, if that.
Well, I would just say, before we hear from the chair, I'm not sure I'm so convinced, because we've heard from other people in these other groups, especially employment and wage, that there's plenty of help, that just we need to expand expand the self-help care centers, expand information about legal access centers. Legal service providers. So I get there's a disconnect in my mind as to why in this group, where we've had someone say very equivocally, and I know other people too, they weren't aware of these things. I just don't get that. There just seems to be a false equivalency here. If all we're doing here is saying, oh, there's already stuff in place, when there's other stuff in place at the other groups, I don't know that we're adequately, we're considering consumer debt, medical debt inside consumer debt. We're doing that already. So that's fine. We can send them a letter to say that. But with regard to some of these other issues about getting insurance companies to make sure they're doing their job, I don't know that just saying that, is there really information? Is this group just going to drop this because we've got a couple of providers? Because if that was the case, then there's unemployment. There's a million other networks, LDAs and immigration consultants and the other kinds of unlawful detainer assistance. We've just scratched the surface here, and you're like, okay, well, there's one thing that does it, so we're done here.
So Carolyn, are you suggesting that we should license paraprofessionals to provide the assistance that the HCAs are providing?
I think if you, it's extraordinarily complicated. And I don't know ERISA law from up and down. Like I said, I'm not an employment lawyer. I'm not an ERISA specialist. But it just seems to me that what the New York group is doing, looking at what social workers are doing, there has to be a way to, covering Mr. Daly's concerns, to take those people and give them another layer of, a certified paraprofessional who can then write that letter when there isn't an attorney like Mr. Katz to take it. I think we said in employment that there are, not enough good lawyers. So if that's the case, if here there's something that's doing the job, but maybe, like I said, I'm the daughter of a social worker, and it happens to be, there are these frustrating times where, you just can't do anymore. And it just seems like this is an area that cries out to say, help that person boost their ability to come from some strength, to say, I can pull, I know those deadlines that Mr. Katz was saying. I don't know. I just, if all that we're saying is there's people out there helping people, we'll just put another letter into the legislature's grasp. I don't know. I'm just not, it doesn't sit well.
Well, the distinction that I see between this and other areas is what I'm hearing is the HCAs serve people statewide, regardless of income. We actually haven't, for free. We actually haven't heard that on any other case type. We've heard, oh, there's plenty of lawyers who'll take these cases on contingency. Oh, there's lots of legal services available, but we're being really explicit that the paraprofessional program is not targeting people who qualify for free legal services. So I do think there's a distinction between what we're hearing about these HCAs than what we've heard in any other practice area. But that really is a decision for this subcommittee. I thought that's where you were leaning. If you're not leaning there, that's fine. But I do think that there's an important distinction. We have statewide coverage A. It's not just limited to certain cities that have decided to fund this. Income unlimited, free. We haven't heard that anywhere else. So that's the distinction in my view.
The further distinction is that there are people operating in these areas now. It doesn't require a law degree. There are health advocates, healthcare navigators, and other professionals, which is also different from any of the other areas. Is it also, am I right, Leah and Linda, that our charge includes closing the justice gap in ways other than licensure? Is that correct? Making recommendations to do so?
Well, our charge is to make recommendations about creating a paraprofessional program and the parameters of that and what should be included in that. But we're not barred from making recommendations in other areas. We can say, as we were researching this topic, these were other issues that were identified. And I think we've heard loud and clear about funding for legal services. I think our recommendations are going to point to that. I think we can, the charter for the paraprofessional program working group does not preclude recommendations that are outside the scope of the program.
So let me just get these two thoughts into the record, lest they be lost on my mountains of paper. And that is that we could recommend that every insurance bill issued in California and every insurance denial has to have the number of your geographic HCA on it, driving consumers like Nicole to their local HCA. And then it sounded like Andy was going to say something.
No, that might have been some stray noise, but I agree with what you just said, Ms. McRae.
Did you have another thought, Dana? Because I did want to clarify something. Were you going to say something else, Dana? I don't want to interrupt you.
No.
Just in the area of administrative agency proceedings, you do have somewhat of a parallel. So there, non-lawyers are already authorized to represent parties in the administrative agency hearing itself. And so one of the concerns that we heard when we talked about licensing paraprofessionals to represent parties in administrative agency proceedings was about disrupting the existing non-attorney market or non-attorney services in that space. The distinction there is that right now the license or the authorization is only to provide advocacy or representation in the hearing itself. And what you will see coming forward as the recommendation to the full working group is to license the paraprofessional to provide legal advice to prepare for those hearings. And right now, if one of these non-lawyers did that, that would be considered UPL. And so what I don't know when we're talking about the medical navigators, for example, I'm assuming they're not giving legal advice because that would be UPL. And so I just wanted to clarify when you said that's another distinction. This is the only place where we have non-lawyers doing the work, that we do have that somewhat in the administrative agency proceeding space. So wanted to throw that in there.
And if I may comment on this, I thank you, Ms. Wilson, for reiterating that point. I think this is one of the most difficult aspects of this conversation, because it's reasonable to think that there could be a consumer protection program if the state of California, in its duties to protect consumers from professions that require licensure, to avoid deceptive practices, to maintain a code of ethics, and all of the things that are parallel to what the state bar does. But I think there's a lot of reservations to be had about an industry that is predominantly individuals who are either working with a bachelor's degree or with a nursing degree or with a social work degree in a field that tends to range all the way from end of life care to handling billing disputes and medical necessity appeals and doing this navigation between providers and insurers. So I understand that the overall subcommittee has declined at various times to expressly define practice of law. I don't think there is enough information that I can be aware of to identify, how rich of a conversation about ERISA is a health navigator getting into. Probably not much. Probably the basic understanding of deadlines and procedure and using the Department of Managed Healthcare's process. But I do think it is very complex of a policy question to try to assert jurisdiction over hundreds, if not approaching 1,000 people in the state, some of whom are working across state lines, and to bring them into a new licensure program under a legal perspective. It just, I think that certainly would require consultation with healthcare stakeholders, other healthcare protection agencies, the healthcare regulators. I think that's a much bigger policy question. In the alternative, then you might be conceiving of a voluntary licensure program, and I think that has its own problems. There are problems of asymmetric incentives to be a part of that jurisdiction, and so I raise that, and I think that's unique among the whole paraprofessional scope. There's no other scope of tasks in the paraprofessional working group where you have this level of an industry. In employment, we did talk about the problem of notarios, but that is where we have widespread anecdotal understanding that there's abuse. I don't think we have that in the healthcare navigator space, from my knowledge.
Thanks. So Dana, how do you want to move forward? I mean, I think one idea is to, again, sort of formally refer the medical debt piece to general civil and just close out this particular subcommittee, indicating, as I said, I don't need to repeat myself. Another would be to just go ahead and say we want to, continue to explore establishing a paraprofessional. I think you're at a little bit of a juncture here.
Personally, I'm in favor of referring out the medical debt defense and making recommendations other than licensure about driving consumers to the services that currently exist. And I know Nicole felt differently at the beginning of this conversation.
Yeah, in listening with referring to the general civil, I'm in agreement with that. And then like you just mentioning, pointing the consumer like somewhere it's available for us to know. Because like I said, I wasn't familiar with that myself and other resources that I've used in the past. So that gives me a little bit of comfort, you know. But if I have access in another area when I'm dealing with my medical debt, it's going to the general civil, then okay.
Nicole, do you want to make a motion to that effect?
Well, I would also ask Andy if he can help us sort of in consumer debt. Maybe he can come help us visit this issue again, because I do know there are those issue spotting things that are going to be critical. I do not know the ERISA guideline deadlines, so I know I don't. I call people like Cam when I. But yeah, I would join in if you want to. Leah, do you have something written? I
don't know that we need, I don't know that we need a formal motion or a vote. I think that if there's just general agreement, then
Okay.
I can, you know, Dana and I can work to draft something, and I can work on so we can draft something from this subcommittee to the consumer debt subcommittee, and then we can also work on a recommendation to go to the full working group.
No, I read the New York thing, and I'm really interested to see what they're going to come up with, you know, to get social. I just think there's so much richness there that I hope we have time to tap into in our group. But
well, you might want to recommend, Carolyn, that the licensing committee take up adding social workers, MSWs, as eligible to seek the paraprofessional license, because right now that is not an eligible population.
Right. Yeah.
Yeah. That would be, I think, a first step if we were interested in the New York approach.
I'm going to think about doing that really seriously. Yeah.
Okay. And Andy and Jack, thank you. And as Carolyn indicated, don't be surprised if you hear from us again.
Thank you. Thank you all.
Nicole, thank you so much for speaking earlier today and then during this meeting. It really helps when we make this real.
Yes.
Thank you.
Yeah, thank you. Okay, everyone, have a
Thank you all. Have a nice weekend.
Bye-bye.
Bye.
Bye-bye.